Hello everyone. So today I'll be talking about compulsory licensing, which forms an important aspect of patenting in India. So consider licensing is something as you giving out your property on rent to someone who uses it for some time and then pays you a rent for that. And compulsory licensing is an aspect where the government issues licenses on a patent so as to serve the purpose of public interest. Since compulsory licensing is a huge chapter in the Patents Act and has different aspects, what I'll do is I'll cover this subject in two different videos, wherein I'll first tell you about what are the different provisions, and then we will look into what are the questions that have come in the previous year's question papers and maybe try and solve those question papers. So before we go on to the aspect of compulsory licensing, what we need to see is what is the basic aim behind granting of patents, and that is provided under section 83, which says that any patent is granted to ensure that inventions are worked on a commercial scale to the fullest extent. Now, the Patents Act doesn't define any definition for what means by working of an invention or a working of a patent. So from the understanding aspect, you may consider working of patent as the commercial exploitation of the patent to the fullest extent that is possible, so that the patented product or the invention is available to the public for use. Further, section 83 provides that patents are not granted so as to enable patentee to enjoy a monopoly by only importing the patented article in India. So in a way, they have to make efforts towards making the patented invention in India as well. Further, patents should not impede any steps that need to be taken so as to improve the public health. So the patents should not in a way restrict any steps that are being taken by the government or by any agencies so as to improve the public health in the country. Further, patents are granted so as to be able to support public interest, and thus there is a socialistic aspect related to patents, that it should serve the society and should not be in a way used in a monopolistic manner. So the grounds for grant of a compulsory license are provided under section 84 of the Patents Act, which says that any application for a compulsory license could be made by any person interested after a period of 3 years of the grant of patent, and the compulsory license could be requested on the grounds that the reasonable requirement of the public has not been met, or the patented invention is not available at a reasonably affordable price to the public. And there's another ground which says that the patented invention has not been worked in India. So remember, I told you that working means it has not been commercially exploited to the fullest extent. In a nutshell, what you can say is that the public's requirement is not being met after a grant of patent has happened and the product is not available to the public in sufficient quantities or maybe at a reasonably affordable price. And these are the basic grounds based on which a compulsory license may be granted by the government. You may note here that a compulsory license could be requested by even an existing licensee of the patentee. So if he already has a license, he could get it converted into a compulsory license. And the definition of person interested has been provided under section 21T, which says the person interested is a person who is engaged in or working in the same field as the field to which the invention in the patent relates to. So out of the three grounds that are given, I think second and third would be easily understandable. But what does actually a reasonable requirement of public having not been met means? So this is provided under section 84 subsection 7. So the reasonable requirement in relation to a patented invention would not be considered to be met in the event the patentee refuses a license, a voluntary license to anyone, and by way of that refusal, it is hampering any new or existing trade or business to develop in India. Or else, if the demand for the patented article is not being met adequately, again, if it is not there in sufficient quantities available to the public, then also it could be considered that the reasonable requirement is not met. Or else, by way of refusal to give a license, the commercial activities in relation to the patented invention are being affected. For example, there is no establishment or development of an export market because of the refusal of the license by the patentee. So this forms an aspect in consideration of whether or not the reasonable requirement in respect of the patented invention has been met or not. reasonable requirements would also be considered to have not been met if in the already existing license there are restrictive conditions that are imposed by the patentee on the licensee, and these restrictive conditions could mean exclusive grant backs, or maybe a bar to challenge the validity of the patent, or coercive package licensing. So exclusive grant back means that if I am giving you a patent, you have to give me exclusive rights on your invention, or maybe your product, or maybe your market, something like that. So you in a way to ask the licensee to give you preferential treatment over others. Coercive package licensing means that you are packaging different things which the licensee may not require along with the license that you are giving on the patent. So in a way you are coercing the licensee to buy things from you or sell your other products along with the patented invention, and that's like pressure tactic that you are putting on the licensee. Also, if there are restrictive conditions imposed in the license such that the market of other products that are not covered in the patent is being affected by that license. For instance, the licensee requires a product B so as to make the patented article, and you tell the licensee that okay, you have to buy that product B from this particular person only, and you cannot buy it from someone else. So in a way you are affecting the market of other products that are not covered by the patent. Again, reasonable requirement is not met if the patented invention has not been worked on a commercial scale to the extent that is reasonably practicable. We have already discussed this. If the patentee is not commercially exploiting the invention to the extent it should have been done, then it could be considered as a reasonable requirement not having been met for that particular patented invention. And the last ground for determining whether a reasonable requirement has been met or not is that the working of the invention is being hindered due to importation. So maybe the patentee is only importing the products from outside India and is not able to import it in adequate quantities, or maybe at an affordable price, and thus the working of the invention within the territory of India is being affected. So whenever a question comes on compulsory license, or maybe you have to advise your client regarding compulsory licensing, you have to specify what are the grounds based on which a compulsory license could be granted, and also explain what each of the ground means. So while explaining that the ground of reasonable requirement having not been met, you have to explain all these aspects which define what is meant by the specific term. So coming to the procedural aspect, section 84(3) provides for the application process. So you need to file an application on form 17 along with the fee, which is provided in entry 28 of table 1 of schedule 1. Along with the form 17, you need to submit the statement of facts based on which you are asking for the grant of compulsory license. So in a way, how each of the grounds, or maybe one of the grounds, or probably two grounds, are being satisfied for grant of compulsory license. Along with that, you need to provide evidence and the nature of interest of the applicant. So whether the applicant for the compulsory license qualifies as the person interested as is required by the provision. Section 87 provides the procedure how to deal with a compulsory license, how the patent office deals with it. So section 87(1) provides that the controller first looks into whether there is a prima facie case supporting grant of a compulsory license. So in a way, he just goes through the application, goes through the facts, and evaluates whether there is a case made out by the applicant for grant of compulsory license. If he feels there is a prima facie case, then the application is served to the patentee and the application is published in the patent journal. The patentee has the right to oppose the application for grant of compulsory license, and he can file that opposition under form 14 within 2 months of publication in the patent journal. Along with form 14, there is a fee that needs to be filed, which is provided under entry 21 of table 1 of schedule 1. Along with form 14, the patentee needs to provide what are the grounds based on which he is opposing the grant of compulsory license, and any evidence that he is relying on, maybe answering whatever evidence has been provided by the applicant for the compulsory license. Also, in the event the patentee is willing to grant a license, then he also needs to provide the terms of a potential license that he is willing to provide to the licensee. So after receiving all the pleadings from both the sides, the controller may appoint a hearing under Rule 98 sub Rule 5, and any party desirous of being heard has to provide a notice under Rule 62, Sub-Rule 2, so as to indicate that he is willing to attend the hearing. And along with the notice, the party has to submit a fee which is provided under Entry 10 of Table 1. Further, Rule 97 provides that in the event the controller does not find a prima facie case as required under Section 87, Subsection 1, then a hearing may be appointed and the applicant is given a chance to represent his case. And after hearing him, the controller may refuse the application for compulsory license or maybe grant further processing of the application. So in a way, the applicant has to justify whether there is a case made out by him for grant of a compulsory license. So after hearing both the sides, if the controller is satisfied that the compulsory license should be granted, then he may grant a compulsory license under Section 84, Subsection 4. Before granting the compulsory license, the controller also has to see what is the nature of the invention and what is the time elapsed since grant, and then what are the measures that have been taken by the patentee so as to work the invention. So it might happen that the invention is a very complex one and it requires substantial efforts to work the invention. So probably the controller may see that a sufficient time has not been given to the patentee so as to work the invention. The controller also sees whether the applicant of compulsory license has the ability to work the invention and what is his risk-taking capability so as to provide capital for working the invention. So obviously you need to make a manufacturing plant, whether the applicant has that capability to bring in that amount of capital so as to work the invention, and maybe what is his plan regarding working the invention so as to meet the requirements. In addition, the Patents Act also fixes a responsibility on the applicant of the compulsory license to have first tried and approach the patentee for a license. So the controller sees whether there has been some effort by the applicant to secure a license from the patentee and whether he was unsuccessful to secure a license within a reasonable time period. So it should not have been that the licensee sent in a request for a license and within a month of doing so he came back and filed an application for compulsory license, because all these discussions take time. Both the sides need to evaluate different business aspects relating to grant of a license. So it should be a reasonable time period after having made that effort to get a license, and that effort should have failed, and thereafter if the licensee makes a request for a compulsory license, then the controller may grant the compulsory license application. Further, in the event compulsory license has been requested on the ground that the invention has not been worked in India, the controller has the powers to adjourn the application if the controller opines that sufficient time has not been granted to the patentees to work the invention after the grant of patent has happened. So like I was telling you about, the invention may be a very complex invention and it may require substantial efforts and time from the patentee. So if the controller feels that sufficient time has not been given to the patentee to work the invention, he may adjourn the application for compulsory license and consider it at a later period. So the maximum adjournment that is allowed is 12 months in aggregate, and this is provided under Section 86 of the Patents Act. So Section 90 provides that the controller may set the terms and condition of the compulsory license while granting it. These terms and condition could include that there should be a reasonable royalty for the patentee or the beneficiary under the patent. So the licensee has to pay a reasonable royalty to the patentee. Then the controller may also include terms to provide that the licensee should be working the patented invention to the fullest extent while also earning a reasonable profit. The controller may impose a condition that the patented articles are required to be reasonably priced. Also, the compulsory license that has been granted is non-assignable and non-exclusive. So different people may be granted license on the patent. Further, the license term is for the balance term of the patent ordinarily. So if the patent life is left for 10 years only, the compulsory license could be for the remaining 10 years, or it could be for a shorter duration as well. Also, the compulsory license would predominantly be to supply to the Indian market only, but in special conditions, if requested, the exports may be allowed by the controller. Also, the licensee has to work the invention in India by way of local manufacturing. It is not required to import the patented article from outside unless there is an express authorization in the license, or maybe the central government requires requests the licensee to import the product from outside in view of public interest. So maybe the patented article is such that it cannot be manufactured in India and it has to be imported from outside. So probably then the central government may want the licensee to import it from outside, or maybe if this particular provision is provided in the license as such, then the licensee is allowed to import the product from outside. Further, if the patented invention relates to a semiconductor technology, then the license on that is granted only for a public non-commercial use. Section 88 provides some of the powers that have been given to the controller while granting compulsory license. So the controller can order for grant of license to the applicant or to their customers in the event that the manufacturing, sale or use of materials that are not covered by the patent is being affected due to the restrictive conditions that are being imposed by the patentee in a license. So if you remember, I discussed about there is a product B that is required along with the patented invention, and if the patentee is imposing some restrictive conditions that you need to buy that product B from this particular person only, then probably the controller may grant the license on the patented invention to the applicant of the compulsory license or also to their customers, so as to enable them to manufacture or use material which is required to work the patent. Also, license may also be granted to the customers of applicant in the event that the purchase, hire or use of the patented article is being affected by way of the conditions that are imposed by the patentee in a license. So in a way, if the customers of applicant are being stopped from working the invention in a particular manner, then the licenses may be granted to them so as to work the invention in a better manner. If the compulsory license is granted to an existing licensee, then the existing license could either be amended or cancelled in lieu of a new license. So while granting the compulsory license, maybe a new license could be issued, or whatever is the existing license, the controller may change the terms and conditions of that in view of what has been decided. Further, if there are related patents and a compulsory license is granted only on a few of the entire bunch of related patents, and if it is felt that without using those particular patents for which compulsory license has not been granted, you won't be able to work the invention in a better manner without infringing those unlicensed patents, then the controller may decide to grant license on the collective group of the related patents. Further, Section 88 subsection 4 provides that the licensee may file a request for revision of terms and condition of a compulsory license in the event after 12 months of working of the invention he feels that the terms are very onerous and he cannot work the invention without bearing a loss towards working of the invention. Then he can file a request under Form 20, which is provided in Rule 100 of the patent rules. Along with Form 20, he needs to file the evidence of how the terms and condition are getting onerous, and a fee which is provided under entry 30 of table 1 of schedule 1. Rule 101 of the patent rules provide that if a prima facie case has been made out by the licensee, then the request is forwarded by the controller to the patentee, who may file an opposition again on Form 14 within 1 month of receipt of the documents, and the process that was specified in Section 87 is followed again. So there is a chance of hearing that is given. Both the sides submit their pleadings, and after the hearing, the controller decides whether the terms and condition need to be revised. So as you know, nothing is permanent, and so isn't a compulsory license. So even a compulsory license could be terminated on request by a patentee, which is provided under Section 94. So the request under Section 94 could be filed by a patentee or any person who is entitled to the patent if the grounds based on which the compulsory license was granted no longer exist. So if the reasonable requirement of the public is being duly met, or if the patented article is available at a reasonably affordable price, or maybe if the patented invention is being worked adequately to the fullest extent in India, then the patentee may request for the termination of a compulsory license, and this request is filed on Form 21 as provided under Rule 102 of the patent rules, along with evidence to substantiate the claim that the grounds no longer exist. Along with that, along with Form 21, you need to file a fee which is provided under entry 31 of table 1 of schedule 1, and this is served to the holder of the compulsory license or to the licensee. So if the compulsory license holder deems fit, he may file an opposition to this request within 1 month of receipt of the request. After both the sides sides complete their pleadings, submit all their evidences, a hearing may be appointed under Rule 102, Sub-Rule 5, and for conducting the hearing, the rules provided under Rule 62, Sub-Rule 2 to Sub-Rule 5 are generally followed by the controller of patents. So this means again both the sides would have to intimate the controller that they would be attending the hearing and they need to provide a fee which is provided under Entry 10 of the Table 1 of Schedule 1. So after hearing both the sides, if the controller feels that the compulsory license need to be terminated, then he would provide a reasoned order terminating the compulsory license. So let us now see what is the legal position in India as regards compulsory license. We'll discuss the only compulsory license that has been granted so far in India in the case of Natco versus Bayer, which happened in 2012. So Natco, a generic company, applied for a compulsory license on Nexavar, which is a kidney cancer drug. So Natco relied on all the three grounds that are provided under Section 84, and a compulsory license was granted by the Controller General of Patents on the following grounds. It was noted that the reasonable requirement of the public has not been met. This was because of the fact that the number of bottles of the drug that were being supplied by the patentee was abysmally low as compared to the total number of patients in India who required the drug. So in a way, the reasonable requirement in terms of quantity was not being met. Then the patented drug was not available to the public at a reasonably affordable price. So the patentee was pricing the drug at somewhere around Indian rupees 2.8 lakhs per month, as opposed to Natco's price of 8,800 per month. So in a way, there was a huge price difference, and thus the drug was not available at a reasonably affordable price. Natco also argued that the patented invention was not being worked in the territory of India because the patentee was purely importing the drug from outside and not making it locally. So in a way, it was held that if you are not making the patented article in India locally, then you are not working the invention. So importation was not being considered as working of the invention. An appeal was filed by the patentee before the IPAB, while the IPAB upheld the decision of grant of compulsory license. However, it clarified that the term working could also encompass importation, and thus there is no requirement as such to locally manufacture the patented article in India, provided there is a reasonable explanation to why it is not being worked in India. So in this case, the IPAB noted that Bayer did not provide any plausible explanation for why it was not manufacturing the drug locally. So in the question paper, if a question on compulsory license comes, you can always rely on this legal position so as to establish how the controller would look into the three aspects or the three grounds and what could be the considerations when deciding whether or not a compulsory license should be granted or not. So this is all about the legal provisions and legal position existing in India as regards grant of compulsory license. In the next video, we'll take up some questions from the previous year's question papers and try and solve those. So if you have liked the video and liked the content, please hit the like button and subscribe to the channel so that you'll get regular updates regarding whatever videos I'll be posting. So see you in the next part of this video where we'll be dealing with some questions of the previous year's question papers.